Hi, everyone. My name is Jatin Shory, and I'm an immigration lawyer here in Canada. I was asked today to give a presentation in the Shades of Africa conference being held October 2020 on the issue of costs of immigration, specifically speaking to going from refugee claimant to becoming a citizen in Canada. And I also will be speaking to some criminality and immigration, the intersection thereof, and kind of focusing more so on youth later on in the presentation as well. I want to thank everyone for joining us today. And for those of you who did attend the conference last year, this will act as a refresher. And for those of you who are attending the conference, this conference for the first time, I hope you get a lot from this and it adds to the perspective of your work and your interaction with your clients. So I want to start by saying thank you to the event organizers. It's tough in the world that we live in today to definitely organize something like this, and I think they're doing a tremendous job of really coordinating the conference digitally and adapting to some of the new tech that's out there. I want to say thank you to the Center for Newcomers for inviting me back. It's always a pleasure to get an opportunity to speak to their partners and stakeholders. So, as I mentioned at the beginning, my name is Jatin Shory. I am an immigration and refugee lawyer based out of Calgary, Alberta, and I actually do primarily litigation. What that means is we do appeals of refused permanent residency applications. We deal with deportations or removals, so these are detention and admissibility hearings. We do a lot of federal court work, so just appealing things like refugee appeals that were denied, appealing different types of spousal sponsorship applications or maybe decisions made at the Immigration and Refugee Board. And lastly, we do a lot of refugee claims as well and protection claims in Canada. So being a lawyer, we have to start with the law. And don't worry, it won't be too much of that. But I wanted to begin by just outlining that there are two pieces of legislation that really matter here. And one is the Immigration and Refugee Protection Act, IRPA, and the regulations, IRPR. So to understand how you even make a refugee claim, and some of you may deal with people who do what are called group of 5 applications, and this is private sponsorship of refugees who are overseas in refugee camps overseas. I'm not going to talk about that. That's a whole different beast on its own. I'm actually just going to focus on I think what more people traditionally understand as somebody who is coming to Canada or is in Canada and wants to make a claim at the border or at the airport. So there are 2 different places, like I mentioned, that refugee claims can be made. The first is at a port, what's called the port of entry, so the airport by sea, and also the land border. The other side is maybe you're already in the country and you've decided, okay, well, conditions in my country have drastically changed, and so you can actually go to an immigration IRCC office, that's Immigration and Refugee Citizenship Canada. You can go to an office and make an application there. It's significant how you apply, and it matters really on when you're applying. So that leads me to the Canada-US Safe Third Country Agreement. You may have heard of this before. It pops up in the media every once in a while. But basically, if you heard about it, it was likely with refugee claimants who were coming from the US into Canada. And so what happened there is that the STCA says that if you landing the US first, and then try to come to Canada to make a refugee claim, well, you got to make it in the US first, because that's a safe third country. This legislation was actually recently challenged in a federal court appeal, because what was happening was that some of my colleagues, their clients, were being denied entry into Canada, but then they were going back to the U.S. and being detained, and they were being detained for indeterminate amounts of time. And so the federal court actually said the STCA is unconstitutional. It's not it's not good legislation or a good agreement, and the government did appeal it. And it's waiting appeal at the Federal Court of Appeal if it's going to go there, and what we'll see basically how that unfolds. But it's exciting. I think from an immigration lawyer's perspective, it's a very positive step for advocating for some of these individuals who are just in tough positions. So there are exceptions, though, to the STCA, and the most common one is family member exceptions. So maybe somebody who's making a claim land in the U.S. first, they're coming to the border, but they have a family member who is either has a claim in Canada or is a permanent resident in Canada or a protected person in Canada or has temporary resident status or something along those lines. So a convention refugee, this is just a definition from the Immigration and Refugee Protection Act. It's important to understand this definition because it really gives you a perspective of what your client or the individual you may be working with who is now a refugee or been granted refugee status, what they had to really prove and what kind of hardship, what kind of issues they had to prove, what kind of risks they had to prove. And so to be a refugee, and this is from the United Nations and just put into our law as well, but a convention refugee is a person who has a well-founded fear of persecution based on their race, their religion, their nationality, or membership in a particular social group or maybe they have a political opinion, and they can't go to their country for protection, and maybe they're not willing to for whatever reason may be, and they don't have multiple nationalities or a different country that they can go to for protection otherwise. And that's a big statement. I mean, if you are interacting with someone who has been designated as a refugee, they won their hearing. Well, they're basically saying, look, my situation was so tough that I couldn't even go to my state, like my government, and seek protection from them. And it's usually because of either race, religion, nationality, and membership. Particular social group can go. There's a number of different social groups that have been found in the law to qualify. But the other side is if you don't qualify for any of those 5 categories, then there is another step, and it's just called a person in need of protection. And so it's a similar kind of assessment, but we're just looking at the individual personally and saying, okay, well, why can't you go back to your country? What are you running from there, and why is your government not able to help or not willing to help? And a lot of situations that I've dealt with are situations where the individual went to their police, went to their government for help. They did nothing, and then they continue to feel face threats and face abuse at the hands of whatever body or person or group they're running from. So it's important to have that context in the back of your mind when you're dealing with somebody who won their application, basically. Now, for this example, moving forward, I've created a bit of a silhouette of like a family, and this is the family we're going to use as an example. I'm going to refer back to them. It's a mom and a dad with 3 kids. It's a common situation when people come to Canada, whether it's through PR or whether it's for refugee claims. They typically bring their family with them, and so we're going to use this family as a sample size. I'm going to refer back to them throughout the presentation to kind of make some points as we move along here. So refugees do have they do have access to an assistance program, and basically it's funds that are set aside to help with food, shelter, clothing, kind of some basic needs at the beginning as well. But there are costs that start to rise up. So work permits, and a refugee claim, if you make a claim, you can automatically ask for a work permit or a study permit, and typically those are granted. They don't charge for that typically, but it's important to understand what that cost looks like. And so generally a work permit, the filing fees, this is to the government of Canada. But the cost is usually $255 when you're applying for a work permit and an open work permit at the same time, and that cost can really add up if you have a lot of family members who need to get work permits. But at the very initial stage, you're applying for refugee protection and you're waiting for your hearing to happen. You can apply for a work permit at the same time, and you don't have to pay for it at that point. But extensions you do have to pay for. So for a family of 4, if they had to pay for a work permit, I'm looking at basically anyone who's 18 plus, that fee would look like almost $1,000 for this family. So on top of that, I mean, there's definitely other costs to think about when you're transitioning into a country. I mean, just basic needs, and sure, you might get some funding from the government, but typically it's not enough, and depending on your family size, it could really be not enough. And you can always look at, I mean, yeah, sure, you can seek higher education and you could probably apply for a study permit, but the reality is that family that's applying for a study permit going to be able to pay international tuition if, let's say, their kids are 18 plus? If you're under 18, you go to school. In Calgary, the Calgary Board of Education will allow you in school. They should allow you in school. I think CCIS is also the same, but typically, if you're above 18 and maybe you're done high school, or maybe you have to do some higher education or upgrading, well, those are private fees, and that depends totally on where you're looking. So that's why we find that a lot of 18 plus, they're still young, children of families that come here, they don't go into school right away, and they instead start just working right away. And it's unfortunate because there's a gap there, and maybe by the time everything is done, they'll be 22, 23, and we'll talk about the impact of that of time as well. But there's a significant period where they're just not being educated, and they're not educating themselves, and it's not because they're choosing to, it's just circumstances are that way. And it's tough to, I'm sure a lot of you would know, to jump right back into school after such a huge gap of time has passed in your education. So I mentioned time, and that's really important here. This is actually an article from last year. Again, I mentioned this is a presentation I did last year, but nothing's really changed, and I felt it was still relevant. Time, it's still taking a lot of time to have your refugee claims heard. And, on average, I have one scheduled for early November, and it took us about a year, maybe a year and a bit for that to be scheduled. So maybe not as much as 2 years, but definitely it still took a lot of time where you're sitting around, you're just kind of waiting to see how the government is going to approach your claim. So you and your refugee claim. This is where the costs really start to build up. So just because you've been granted refugee status, just because you've been granted protected person status, does not mean that you have permanent residency in Canada. You actually have to be proactive, and you actually need to apply for that status. And so there are fees now associated with all of that. So for a protected person, for example, or a refugee convention, a person found to be a convention refugee, their application fees are broken down in this table right here. And so the principal applicant, that would usually be the mother or the father, whoever it was that won the claim, basically, would be paying $550. If there's a spouse, $550, and then dependent child, $150 per. So total for this would be about $1,250, just starting with, I believe, just one dependent child. And so it's important to understand how a dependent child is defined. So as of 2017, a dependent child is defined as someone who is 22 years old and under. Under 22 years old. So if you're 21, you're good. If you're 22, you're not good. You're not a dependent child. It used to be 19, but now it's 22. So looking back at that family that I mentioned earlier on, you can see how now the application cost actually changes. So when I look at mom, dad, and son, because it took about, let's say, 2 years for the hearing to happen, for basically a decision to be made, mom, dad, and son, their application is going to be about $1,250. But now, see, the daughter is 22 years old. So now she has to do her own application. So she's going to be paying $550. And then there'll be another application for the 25-year-old. And she will be paying also $550. I see the error there, application 2. It's actually application 3. On top of that, it's going to take them almost 2 years for that decision to be made on their application. And I have to emphasize, I mean, a lot of this is pre-COVID estimates. And with COVID now, we really don't know what that's going to look like. So a significant amount of time, I mean, we're talking years have passed since they got to the point of being able to apply for permanent residency. So the cost of the family has almost doubled just because of the time that has passed. Eventually, permanent residency is granted. A couple of years have passed, and congratulations, you're now a permanent resident. The next step is citizenship, and this is really where I think a lot of families stop. They don't really actively pursue citizenship as much because life happens and other things just take priority, and lots of people can get married, and I mean, who knows, but so much time passes by that when you get PR, a lot of families typically stop there. And I always tell clients that I see with the potential of qualifying for citizenship to go for citizenship. And I suggest all of you who are watching this presentation, if you find yourself dealing with somebody who is a permanent resident and it's important to ask, why have you not applied for citizenship yet? You do have to qualify, and qualifying is typically 3 out of 5 years of being a permanent resident. So you wait for 3 years and then you qualify. But physical presence also matters in Canada itself, because there are permanent residency obligations that you have to stay in Canada. People need to file their taxes. So there are some document requirements, no doubt, but they're not difficult by any means. There's nothing really complicated about applying for citizenship. I think the toughest part is the English examination part. And if you went to school here, if you're like the 14-year-old that we mentioned, he's going to school in Canada, he will qualify. He will not need to prove his English capacity. But if you didn't go to school here, then you need to do an English test. And so typically, how that happens is you go to testing centers. So you can provide proof of education in Canada as an alternative to needing to write that test. Typically, parents don't have any education in Canada, and so they're the ones who have to usually do the test. And sometimes the kids in that 3-year gap do attend school. They eventually get various diplomas or degrees, and you can definitely use that as support for English. But if you haven't, in our family, well, I pulled out some data of some local testing happening right now. You can see that English testing in Calgary, last year was about $190. It's already gone up to $280. And so the testing itself is increasing in cost. Like that, it's a huge jump for me. That was surprising when I saw that. But you can see that the cost is about $280 for most places per person. Now, when we look at this family of 4, we have the 26-year-old, we have mom and dad, and we have the 29-year-old, assuming that they are all, especially the 2 daughters, let's say, assuming that they haven't been married yet, then that family would be paying about $1,100 for just testing alone. So then we look at the application fees for citizenship, and you can see that any adults who are 18 and over is $630 per person. And anyone who's a minor, well, they're $100. So for the family, the total cost for applying for citizenship is about $3,400. And that what I did there was that I included the cost of the testing in there as well. So just to clarify that point. Now, I apologize. The number here isn't fully correct. I forgot to change the citizenship numbers right here. But for permanent residency, then citizenship English testing, it's actually in the $1,100. Then citizenship the total cost is about $3,400, $3,500. You're basically looking at about $6,500, $6,600 that the family needs to save, and they need to basically spend towards getting status and securing themselves in Canada. And I think many understand that a lot of individuals who come through refugee streams or protected person streams are not, the most financially secure right off the bat. There's a lot of time taken to create a foundation. There's a lot of time taken to create some, security around them, taking care of basic needs, housing, stuff like that just take priority. And that's normal. I understand that. But it's important to give you, as a practitioner who likely works with vulnerable immigrant newcomers, to have this kind of in the back of your mind and understand that this is what they're facing, really. Why have they not applied for citizenship? Well, it's not because they're just lazy or because they feel that, they just never prioritized it. No, there were significant costs associated with it. And these are fees that you have to pay up front. And these are fees that you have to, budget for on top of everything else. So just some perspective, really, on getting from refugee to citizenship. I want to transition quickly, as I mentioned earlier, to some youth criminality and speaking to how that works in the immigration world. The law, this has come from the Immigration and Refugee Protection Act, Section 36. It defines serious criminality as a permanent resident being inadmissible for being convicted of a crime, basically, that's punishable by a maximum term of imprisonment of at least 10 years, or being sentenced to a term of imprisonment that's more than 6 months. So Section 36.3 looks at inadmissibility. So what it says is the following provisions govern Section 1 and 2. So inadmissibility under 1 and 2, 1 being serious criminality, may not be based, and you see point 2, on those who are found guilty under the Young Offenders Act, and then point 3, or the Youth Criminal Justice Act. So basically, if you're a youth and you committed a crime that would typically fall under serious criminality, then you don't have to worry about immigration consequences yet. You won't be found inadmissible. You will not have to face the roller coaster ride, which is basically trying to fight for your status back. But that doesn't mean you get off scot-free. I ask usually, especially through the Real Me program, what kind of issues they're dealing with, especially with their youth, and a lot of them said, basically provided me some feedback, and I compiled a list of those common issues, from assault to robbery to drug dealing. There's a number of things that youth are getting involved in today who are finding themselves in these types of programs, and so I wanted to just kind of explore them really quickly. So for assault, you can see that it's a sentence maximum of 5 years. So it wouldn't fall into the serious criminality provision, but then, a lot of these youth do get caught with assault with a weapon, or by assault that causes bodily harm, maybe in a serious fight or what have you. Then all of a sudden you do fall into the category of serious criminality. And there's just different levels of assault that I've highlighted here, for you to review. But, what's important to understand is that this this conviction could matter because eventually you get to what I call access periods, and I'll get to that. For motor vehicle theft, you can see it's a 10-year, it's 10 years, so it does qualify. You can see theft, same thing, 10 years, it does qualify. Robbery, for sure qualifies. And so understanding, and the source is right on the left-hand side there, but understanding the way criminal inadmissibility works is basically, if they find you may be suspected of being criminally inadmissible, the CBSA, the Canada Border Service Agency, is the one who really comes after you. And they basically approach you, and they'll give you an opportunity to respond and say, hey, listen, we think you're inadmissible to Canada because, here's a conviction that we were told about by the RCMP, and this is why we think it qualifies. But, you have a shot here to kind of explain to us otherwise. Maybe you can throw in some humanitarian reasons why we shouldn't write a report, but we are about to write a report. And if the Canada Border Service Agency decides to write that report, then eventually it's the decision on whether or not you are inadmissible goes through a formal process. It goes through an admissibility hearing through the Immigration and Refugee Board. And then basically you go and the board member there will say, yeah, you're inadmissible, or say, no, you're not inadmissible, based on whatever arguments you present. Most of the time, though, you are inadmissible, and that's not where you're going to be trying to plea for, any humanitarian or compassionate agreements or any concerns that you may have. That's just not the place for it. But basically you lose your status, you lose the right to work, you lose everything that comes with that status. And ultimately the Canada Border Service Agency is then obligated to proceed with removal from Canada. A deportation order is issued at the hearing, and they're going to start processing you for removal from Canada. And you're typically offered an opportunity to give what's called a pre-removal risk assessment, which is basically you going through that Section 97, if you remember, kind of an analysis like that. And it's what we call a limited prop. I'm not going to get into that right now, but generally speaking, I mean, you're going to be going through now what could be potentially the next 3 to 4 years of your life trying to fight for status. You can apply for a humanitarian compassionate application. Typically we do after the fact, if you believe there are reasons that explain why, given your criminality, you should still be allowed to stay in Canada, still be given permanent residency. But generally speaking, you gotta buckle up for about a 3 to 4, possibly 5 year ride of just trying to figure out your status, and everything else in your life will stop because you do not have status right now in Canada, and you have to reapply for a work permit, and you can't go to school if you're in school, and there's so many complications that just come with it, and everything in your life just gets put on halt right there. I mentioned access records. This is why it's important for youth and those who work with youth to understand the importance of a conviction. This is just something I pulled out from the Crown, just from the website, and basically access periods are periods where your conviction, even if you got it as a youth, will still be on your record. Basically, they'll still pop up if you get in trouble after you become an adult. So if you got convicted of something that stays on your record for 4 years at the age of like 16, well, that's gonna be on your record till you're 20. So if you get in trouble after 18, this record, which should be not on your this conviction, which should not be on your record as an adult, will then get put back in front of the Crown, in front of the judge, and it can become part of your record. And all of a sudden, what would have been a situation where you were not inadmissible to Canada for serious criminality, all of a sudden you are, and you're now at risk of losing your status at the age of 18, 19, 20 because of something you did when you were maybe 15, 16, 17. So it's really scary. It's really important that youth understand that, especially if they enter conviction and maybe they're trying to change they enter conviction and sentence, and they're trying to change their habits maybe or what have you, but it's important for them to understand that. It's important for any individuals who work with youth to understand that. So that's it for me. That I appreciate for those of you who made it to the end of my presentation. I will be available for questions at the end of this presentation on the week of the conference as well. My contact information is here. Please, no formalities. You can feel free to send me an email if you have any questions. You want to pick my brain. You want to talk immigration. You want to talk criminality, refugee cases, whatever. I typically work with stakeholders and partners on a pro bono basis. I understand the clients you're dealing with, and again, I have no problem speaking with you or your team, going and kind of just working through any issues you guys may be facing. Again, no formalities. And lastly, I thank the organizers again. I hope everyone gets a lot out of this conference. I know I did last year. I'm sure I will this year again. So thank you again, and I hope everyone stays safe during this global pandemic here. Thank you.